Oyez, oyez, oyez. The Court of Appeals for the 4th Judicial Appellate District is now open pursuant to call.
Welcome, everyone. Please silence your cell phones first, and please mute your microphone except when you're arguing. I really would appreciate it. Today, the court will hear arguments in the case of Rancho Viejo Cattle Company versus ANB Cattle Company. Style is 2143 CV. The appellant has 20 minutes to argue. The appellee has 20 minutes to respond, and then the appellant has 10 minutes to reply. Can you all see the timer in the screen? We would appreciate if you stayed within your allotted time, and when the light turns red, your time has expired. If we grant the appellant additional time, we will give the appellee additional or the same amount of time if requested. If a party's connection is, as the clerk advised you, if the party's connection drops, we will pause the timer, suspend the argument until the connection is restored. After the connection is restored, we will restart the timer and resume the argument. If by any chance someone cannot connect or the connection cannot be restored within 15 minutes, we will reschedule the argument. Let me call for announcements. The appellant.
Josh Morrow here for Appellant Rancho Viejo.
Are you going to be the only attorney arguing for the appellant?
That's correct, Your Honor.
Okay, thank you. Appellee?
Dan Posa for ANB, Your Honor.
And you'll be the only attorney arguing for ANB Cattle Company, correct?
Correct,
Okay. Now, if you want to take a drink of water during your argument, please do so. And when you're ready, Mr. Morrow, you may begin.
May it please the court. The judgment below should be reversed because it disregards two rules. Number one, a restrictive covenant requires restrictive language. And all we have here is the mention of a contemplated use. No restrictive language, so no restrictive covenant. Number two, a co-tenancy cannot be formed unless both parties at the time of formation have a present possessory interest. And here, ANB has never had a possessory interest in the disputed tracts. No possession, no co-tenancy. ANB's brief ignores these rules. They do not identify any restrictive language. And instead of identifying a possessory right that they ever had, they merely assume that a co-tenancy exists and go from there. This court should reverse the judgment below and render judgment for Rancho Viejo. For the court to do that, we need to prevail on both points. I want to start with the so-called restrictive covenant. The trial court's judgment recognized that Rancho Viejo has the exclusive right to occupy what we call the disputed tracts, and that Rancho Viejo has exclusive possession of the disputed tracts. But that judgment declared that Rancho Viejo's use of those tracts is limited to hunting and grazing purposes. That declaration must be reversed. Tab A of our bench book shows why. And we have there set forth the language from the cross conveyance that ANB says creates a restrictive covenant. So beginning with that language, beginning with the text, as we must, the first thing you see that we have highlighted here in yellow is that this language excludes users. It does not exclude uses. This is affirmative language that states what Rancho Viejo kept as part of the cross conveyance. Because remember, prior to the cross conveyance, Rancho Viejo owned these tracts outright. So with the cross conveyance, Rancho Viejo gave an interest to ANB. The language highlighted in yellow shows that Rancho Viejo kept exclusive possession of the tracts, of the disputed tracts as part of that conveyance. After that exclusive language, we come to the 5 words that stand at the heart of this issue. And those words are for hunting and grazing purposes. Now, I want to point out that these words are not restrictive. The word for is not a restrictive word. For is an inclusive word. If I give my child a backpack for books, I will not be surprised to find pencils in the bag. If I want it to be only for books, I've got to use a word like only, or like solely, or like exclusively. And it's the same thing with restrictive covenants. And we know that the parties knew this rule because they used one of those words earlier in this very sentence. They used the word exclusive multiple times. They used that word when they were talking about users. But when we come to the hunting and grazing language, we find that there is no restrictive language, only the word for. And the reason is that these 5 words about hunting and grazing state only a contemplated use. Hunting and grazing are what these tracts were used for at the time. And it's one of the main ways that tracts in this area can be used profitably. So it was very important to the parties to make clear that this cross conveyance would not affect their right to use the tracts for hunting and grazing. But we know from the Trant case and from other cases that tell us the same thing, that the mere statement of a contemplated use does not create a restrictive covenant. Instead, you need restrictive language. And so the text here is dispositive. These 5 words are not restrictive. No restrictive language, so no restrictive covenant. Now, A and B responds that there must be a restrictive covenant here. And they've only got one textual argument. That argument is surplusage. A and B says, when you look at the language that we have highlighted here at tab A in green, you've got 5 words that say for hunting and grazing purposes. And A and B says, look, if we assume that these are a restrictive covenant, we've eliminated some surplusage from this instrument. But that argument fails for the reason that I've already stated, which is the Trant case and the Texas Supreme Court's decision in the First Baptist Seminary case. Those cases make clear that the mere statement of a contemplated use does not create a restrictive covenant unless you have restrictive language. So, for example, in the Trant case, the deed conveyed to the city of Houston some land that was anticipated to be used for a landfill. Later, the city tried to use the same land for a shooting range, and the grantors said, hey, our deed says that we only expected y'all to use this for a landfill. And the court said, well, that's just a deed that states an anticipated use. The language was not restrictive, so there was no restrictive covenant. And the First Baptist Seminary case is similar. In that case, a seminary conveyed a piece of land to a church, and the deed stated that the purpose was to secure a loan. Later, the church, independently of the loan to the seminary, mortgaged the deed. And the seminary said, hey, you can't mortgage the deed. We only gave it to you to secure the loan. And we're up to date on our loan. And the Texas Supreme Court held that there was no restrictive covenant in that case because the deed stated only a contemplated use. And it's the same thing here. For hunting and grazing purposes is only a contemplated use. So the argument from surplusage really doesn't get you anywhere. Yes.
Mr. Morrow, I've got a question. And by the way, we're going to put our hands up whenever we have a question. That'll help both of you in responding to our questions. So what would the language be if it was a restrictive covenant?
Well, to impose a restrictive covenant, you would have to use restrictive words. So the language have to be, can be used only for, or can be used exclusively for, or can be used solely for. The exact type of language that the parties used in this same instrument when they were excluding users. So they knew the rules of the English language about restrictive words, and they use restrictive words to keep out users, but they did not use restrictive words in the clause that talks about uses. So
But isn't there some inherent tension in the fact that this clause sets out those two uses? You're trying to argue, no use was prohibited, but then why set out these two uses? I mean, if you had the ability to go back in time, wouldn't you strike that for hunting and grazing purposes language out of this?
well, it was important for the parties at the time to use these words because these are some of the only profitable uses that land in this area can be put to. And they wanted to make sure that with this cross conveyance, which was limited to a certain purpose, ensuring the right to surface use payments, that cross conveyance didn't affect any of their other profitable enterprises that this land could be put to. And the cases I've just talked about make clear that parties are free to do that. There are often conveyances where, as in the cases we cite and just discussed, the parties have an important use that they want to make sure and set out that there can be no dispute that those uses are permitted. And that's what happened here.
Let me ask you this, Mr. Morrow. Are you saying that the words exclusive right, really what they mean is they're excluding A and B from hunting and grazing in the land and issue?
Well, that's among the exclusions that apply to A and B. So Rancho Viejo has exclusive possession. And that possession is exclusive to any purpose, any surface use of A and Bs. So not only hunting and grazing, but any other purpose, because the right that.
So why not put that there?
Well, I think that's what the text does say, and you have to remember, Your Honor, that this conveyance is a grant from Rancho Viejo to A and B. So this isn't, somewhere up in the chain of title where A and B and Rancho Viejo both received something. Rancho Viejo owned these tracts outright. A and B had no interest in them. And Rancho Viejo gave something to A and B. And the purpose of this language is to define what that interest is.
Mr. Morrow, is it your position that the language or that the hunting and grazing language that is in that's included, is it your position that it is not ambiguous, that there's just merely a disagreement between the parties?
That's correct. Neither side has argued ambiguity in this case, and I think again the cases that allow parties to state contemplated uses eliminate any argument about ambiguity.
Okay, and would you address the legislature's enactment of the property code section 202, where we know that the common law has always held that we are to strictly construe restrictive covenants because the law favors free use of property, correct? But in 1987, the legislature enacted the construction of restrictive covenants section, and it says that we are to liberally construe to give effect to purposes and intent. So can you reconcile those two for us? What are we to do in construing whether a restrictive covenant exists?
Well, in this case, I think the legislative enactment is not really an issue, because that enactment, as I read it, is about how you construe a restrictive covenant that does in fact exist. It's an enactment about scope. And the issue here is existence. Does a restrictive covenant exist in the first place? And so I don't think the property code has anything to say about that construction. And I think you do come back to the common law principles that if you want to have a restrictive covenant, you've got to state it clearly, and certainly you've got to use restrictive language, but I don't think that, liberal versus strict construction principles are dispositive here. I don't think the property code even applies because of the scope versus existence issue I just stated. But I think the common law does help inform about whether a covenant exists in the first place. So I do want to briefly mention the purpose, because both parties have talked about purpose in this case. And rather remarkably, in this case, both parties agree what the purpose of this language is. A and B said that below. They said it in their brief here, and we agree. The purpose is to make sure that A and B can get surface use payments under the Relinquishment Act. And so A and B says, well, in order to vindicate that purpose, we need a restrictive covenant. And that's just not correct. And there are two reasons why. First, the surface estate is already dominant. So restrictive covenant or no, the surface estate already has a right to drill. And in this second, in the context of the Relinquishment Act lands here, surface owners have a fiduciary duty, a statutory fiduciary duty to the state to ensure that tracts go leased if needed. And so A and B says, well, we've already got those two protections. What the parties wanted to do here was add a third protection. It was very important to them to ensure minerals could be produced. And so they added a restrictive covenant. But how did they do that? They decided to add a third layer of protection using a so-called restrictive covenant that doesn't use restrictive language, although earlier in the same sentence we have restrictive language, and that doesn't even mention mineral uses. And that reading and that reliance on purpose, I think just strains credulity. I do want to talk briefly about co-tenancy as well. It's the second issue here, and I think it's more straightforward. And the reason is that it's black letter law that the formation of a co-tenancy requires both parties to have a present right to possession. And A and B has never had a present right to possession of these tracts. At no point in time has it ever had any possessory right. Oh, yes, I'm sorry.
Yeah, but let's go back to the 1990 cross conveyance. It says, do hereby cross convey an undivided 1/2 interest in the blah, blah, blah in fee simple.
That's right.
So, fee simple to me means that it has all the attributes of a fee simple, including possession. So how can you distinguish that from the cases that you sent us? Because those are not fee simple cases.
They're freehold cases in terms of the life tenancy cases. I believe you're referring to, but the answer here is the instrument does say fee simple, but you can't stop there. You've got to keep reading to see what are the limits. When we see fee simple, that doesn't mean surface and minerals. Those estates have been severed, so you can't argue surface and minerals. In the same way, you can't see fee simple and say, oh, well, it says fee simple, so A and B has got Rancho Viejo's undivided interest. Fee simple is about the length of the ownership right, and the hallmarks of a fee simple ownership are that it's divisible.
So, Mr. Morrow, can't the parties to agree who's going to possess and who's going to use? But when you convey fee simple, it also conveys the right to use and possess. But do you agree that a party can actually agree to allow a co-tenant to have exclusive use or possession?
Well, one, I agree that absent other language, Your Honor, a fee simple would convey a possessory right, but in this case, that right was expressly withheld. And second, I also agree, Your Honor, that once a co-tenancy is formed, co-tenants are at liberty to contract about possessory rights. But here, a co-tenancy was never formed.
So so what you're saying, if I'm understanding you correctly, if this property had been conveyed, but excluding the possessory language, who had exclusive possession, and did that the next day, then a co-tenancy would have been formed and the parties would have then reached an agreement. In that sense, then they would have had a co-tenancy?
Absolutely. If there had been ever been a possessory right, and possessory rights are the hallmark of a co-tenancy. And so if that right had ever occurred here, I agree. I think there would be a co-tenancy, but the record tells us at page 783 that this cross conveyance was effective for all purposes at a single point in time. So this cross conveyance conveys a single interest. It doesn't convey a fee simple and then some point later restrict that fee simple. Just as it doesn't purport to convey the state's mineral interest and then retract it. It's only conveying a single interest, and that interest here is just not possessory. And we know that because the cross conveyance is text, and because the language that says the interest is subject to these exclusive rights.
Are you saying that we can sever surface rights? You know, we know that we can sever mineral rights. Do you agree between tenants or among co-tenants? But are you saying that we can sever surface rights?
No, not in the same way. But we know from the cases that we've cited and the ANB has cited that parties can adjust possessory rights, and that they can do that as co-tenants, or that they can do it when the initial right is conveyed, as happened here. A surface ownership interest was conveyed, an undivided ownership interest, but it simply did not include the right to possession. And so what we have here is what is just a simple joint ownership. It's not joint tenancy, it's not co-tenancy, it's just joint ownership, because there was never...
The cross conveyance conveys fee simple, as Justice Alvarez pointed out in the language. And when someone conveys property in fee simple, does that not include a right to use, possess, and dispose of property?
By default, yes, but here the parties excluded that right.
So you're saying that even though it conveyed it in fee simple, the party only conveyed the right to do what?
Conveyed a right to have a surface ownership interest in this land that guarantees ANB a right to surface use payments, and that ANB is free to sell or dispose of as it wishes.
Is there any authority, and I didn't find any authority that you can direct us to that authorizes the severance of all the surface rights?
I think the best case, forgive me, Your Honor, I think the best case for that proposition being, an ownership that does not include possession, is Lane v. Hughes, and we cited that in the briefing below, and it's at 228 Southwest 2nd, 986, and in that case, a mineral owner conveyed away all the minerals and retained an interest in any minerals that would be produced in the future.
Your time is up, and you'll have 10 minutes for rebuttal. Unless Justice Watkins, do you want to ask a question? So wait, hold on. We'll give the appellee the same time if he requests it. So please go ahead.
Thank you so much. Mr. Morrow, so let's just assume that the court agrees with you on your restrictive covenant argument. But say we disagree with you on co-tenancy. How would our judgment read?
So in that case, I think the court would reverse and render on co-tenancy, and then on restrictive covenant, if you believe that there's a restrictive covenant here, I think reversal is still required because there's a missing factual connection between a co-tenancy and the trial court's judgment here that Rancho Viejo lacks legal authority and to use the tracks for solid waste landfill facilities. And that connection is that a factual determination that the proposed uses that the record reflects would constitute waste or despoilment or something like that, that we know co-tenants can object to.
Thank you.
Any other questions, justices? No? Thank you very much, Mr. Morrow. Mr. Posa, are you ready?
I'm ready, Your Honor.
Please proceed.
Okay, may it please the court. Before jumping into our co-tenancy hunting and grazing debate, I'd like to briefly talk about two other declarations, and really the formation of my argument really is grounded in what I call the four declarations, and I number them 1, 2, 3, 4. They're not numbered in the judgment, but just from top to bottom, it's co-tenancy, the solid waste facility, hunting and grazing, and fiduciary. And I'd like to talk about 2 and 4 briefly. That is the solid waste facility and the fiduciary declarations before jumping into the hunting and grazing and co-tenancy declarations. And I think it's important to be cognizant of the fact that what the court's looking at is whether it's affirming or reversing with regard to the judgment, right? Not necessarily the arguments of the parties. That can be broader than what has actually been declared. So by way of example, what I call number 4, the declaration concerning fiduciaries, that the defendants have no legal authority to impair, inhibit, or destroy, etc., in the development of the underlying mineral estate. I don't really see that as controversial or even contested. I noticed that in the issues presented by Rancho Viejo, their actual issue 1C is Rancho Viejo a fiduciary to ANB for matters that do not involve mineral operations. So they're actually attacking a declaration that was not made by the court. So I think it helps us to be moored, if you will, or grounded in starting with the 4 declarations and then proceeding from there, and perhaps with also looking at the issues actually presented. So I don't see a controversy with regard to number 4. And I don't see a controversy regarding the solid waste facilities what I call the 2 no legal authority declarations, 2 and 4. Fiduciaries would have no legal authority to impair, inhibit, or destroy the development of the underlying mineral estate. I think that's clear from the record and clear from the law. And 2, with regard to solid waste facilities, that's merely an example of 4, right? It's a use that would impair, inhibit, or destroy. In the Texas Health and Safety Code, I think we cite on page 4 of our brief, 361.003, the 36 definition of solid waste facilities describes that which is being referred to by the court in this declaration 2. So 2 and 4, I think are pretty straightforward, and I'm not sure they're really under any sort of attack from the other side, in particular 4. There is another more straightforward reason why Declaration 2 concerning the solid waste facilities requires the plaintiff's authorization and consent, and it's not merely because it would impair, inhibit, or destroy the development of the underlying mineral estate. It has to do with a use which is not contemplated in the agreement. And so the agreement as described on what I call page 2, I keep numbering things here, but the partial reproduction done, I'm referring to the cross conveyance I can read, which is the partial reproduction that Rancho Viejo did. Page 1 is our fee simple conveyance, cross conveyance, and page 2 is our agreement as to possession and use. So jumping into sort of the heart of the appeal, if you will, the reference to the judgment is this discussion involves the co-tenancy declaration, which I number as 1. It's the first one. Then the third one, that there's a limitation, and notice that the court does not use restrictive covenant language in its declaration. It says limited to hunting and grazing purposes. And I think I know why the court did that. And I think the trial court was a close reader of the 1990 cross conveyance. And as a close reader of the 1990 cross conveyance, would use the language that the court used in all four declarations. So I would like to talk about co-tenancy, and I'd like to talk about hunting and grazing purposes. And I'd like to do the best I can to stay within the four corners of the cross conveyance. Both parties have given reasons, background information, surrounding circumstances. One might say both sides may from time to time have gone even further than that in trying to justify, explain the documents. And although that can be informative, and in certain situations that's proper, the best evidence in an unambiguous document is enforcing the plain language. And here, I think the declarations from the court with regard to co-tenancy and hunting and grazing purposes can be affirmed or reversed with a close reading, as the trial court did, of the cross conveyance. So I start with what I call page 1 from the partial reproduction. It has to do with co-tenancy. And it seems to me that we have a very straightforward cross conveyance of the fee simple interest in a 50% undivided interest in the surface estate that each party owned. 50% of that is conveyed in fee simple to the other party, or cross conveyed. And to me, that is very straightforward, but the kicker, or so to speak, the clincher, if you will, is the fact that we have on page 2 an agreement as to use. If there was not a present right of possession, if these parties on page 1 did not hold interest in each other's property in fee simple, that is these surveys that we're discussing, if they did not hold those in fee simple, there is no reason for page 2. If there is never a present right of possession, why are we talking about anything on page 2 having to do with agreement as to possession and use? It would be unnecessary. In fact, it would not make any sense. The only way it makes sense, and the parties understood this at the time at least, the only way it makes sense to have an agreement for possession and use is if in fact there is a present right of possession. And because there's a present right of possession, and because they, if you so to speak, want to have their cake and eat it too, both parties want to have their cake and eat it too. They want the state of Texas mineral rights. They want the value of that, but they still want to have exclusive possession as they had it before. Well, they've lost exclusive possession through the conveyance. So how do we regain that? Well, no problem. Co-tenants can reach agreements. And so these co-tenants, each with a present right of possession in each other's property, these surveys, reach an agreement. And that agreement is on page 2. And it's only because they have a present right of possession that this agreement makes, that there is even agreement that's being discussed. And frankly, the agreement to me is pretty straightforward. I know it's been deconstructed very specifically by Rancho Viejo, efforts by ANB as well, but really straightforwardly, the agreement basically is how do we have our cake and eat it too agreement, which is how do we maintain exclusive possession? How do we remain in exclusive possession when we've conveyed fee simple interest? And the parties agreed quite clearly on page 2 that they would do so, but there'd be a price to pay. There'd be some consideration for that. And that consideration, that price they would pay, is the use. And that is the use would be hunting and grazing. So we have a present right of possession. We have our fee simple interest. We've cross conveyed. We want to be owners of the soil with regard to each other's surveys that are under discussion here. Yet we want the benefit of exclusive possession. And so we will do that, but we will pay a price for that. We'll have consideration for that. And the consideration for now remaining in exclusive possession will be a limit, and as the trial court just calls it, not a restrictive covenant, although it could be a covenant since it's in a real property agreement. They agree in covenant, but the consideration is we're going to limit the use to hunting and grazing. And for that use, we have this agreement.
But Mr. Posa, the finding of the trial court says limited to hunting and grazing purposes.
Correct.
So the trial court grafts the word only, it seems like, onto the end of for hunting and grazing purposes. And I understand and appreciate the history that you've provided, but it seems to me that perhaps either side's interpretation requires us to either add or delete words to this conveyance.
Well, the way I sort of come at it maybe overly simply, but I sort of start on page 1, and we have people with these parties with fee simple interest, and they have a present right of possession. So obviously, Rancho Viejo appeal is dependent upon that not being the case. I think it is the case. Page 1 says it is the case. So when I look at the agreement, so the parties as co-tenants now on what I call page 2, enter into an agreement where they will remain in exclusive possession. Now they have to reach that agreement because if they don't do anything, they have the right to possess each other's property. It's not exclusive. And so in order for it to be exclusive,
Let me ask you a
Yes.
question, and I'm sorry for the interruption. You brought a really good point, and you said that the parties had been using their respective lands for hunting and grazing, right? So wouldn't this language saying that they can continue that use exclusively, because that if they continue hunting and grazing their own property, they can benefit. They don't have to share the proceeds from hunting and grazing. They have exclusive use of that in their lands versus that they can only do hunting and grazing on the land.
correct. And so my point, hopefully simply, is that if they want to do something else and still have exclusive use, they need to reach a further agreement. The trial court calls it the other party's consent, but you have to reach a further agreement. For instance, in the stipulation, they tweak the agreement they reached in the cross conveyance. I think they changed the taxes, ad valorem taxes some. Well, that's another agreement. In fact, in the stipulation, it talks about it embraces the prior cross conveyance agreement and says, in addition to those rights and obligations, we're going to do the following. We agree in covenant as follows. So they can reach another agreement, but they have to reach another agreement. Otherwise, they're back where they started as co-tenants with a present right of possession.
So what you're saying, excuse me, so what you're saying is it's really not a restrictive covenant that they can only do this, but they can use the land for hunting and grazing. And if they're going to use the land for something else, they need the authorization of the co-tenant. Is that what you're saying?
Yes, Your Honor. So they need our consent, or they need to reach a further agreement. So I think. And I'm not saying, for instance, ANB on fiduciary had a broader argument than what the trial court found. ANB had broader arguments in the trial court with regard to and raise the issue of restrictive covenant. I don't think that survived. I don't read the trial court as saying that survived there. I think what the trial court did, again, going back to my point that I think the trial court did a close reading of the cross conveyance. We have two parties, and it may be simple, but it seems very direct and straightforward. And that is, we have two parties that have cross-conveyed fee simple interest in the surface estates, 50% undivided, and they want to enter into an agreement about the use. And that agreement is going to be, we'll limit the purpose to hunting and grazing, and for that, we'll give you exclusive use. If you want exclusive use, to build a solid waste facility, to do other things, no problem, but you can't do it without a further agreement. You can't do it without consent or a further agreement. That's what I think the trial court did in its declaration.
So it's really not a restrictive covenant. It's just saying right now you can continue with the grazing and the hunting, and for any other use, because we're co-tenants, any other use, we just follow the law of co-tenancy, correct?
Exactly. We're back where we started. On page 2, we come in with present rights of possession. We enter into an agreement. Our complaint is the use that they are attempting and claiming to have a right to is a use that's beyond the scope of the agreement. You need to come back. You need to get another agreement because we're co-tenants, or you need to get our consent. They chose to do neither of those. That's why the trial court's declaration is the most straightforward, and that's why I started off trying to gear us from actually what the court's interested in, and that is the judgment itself, because the arguments have been broader. A and B's arguments have been broader than what survived. We chose not to appeal any aspect of it, but not every argument we made in the trial court, not every argument we made on appeal responding to some of Rancho Viejo's. Yes, ma'am.
I'm sorry to interrupt you again. I'm trying to put this in my head, okay? So what you're saying is, A, there is a co-tenancy because of the fee simple.
Yes.
And B, we follow the law of co-tenancy. And
Yes.
they did carve out the hunting and grazing.
Correct.
They can continue doing it. Each party in their own land can continue doing it, and the other party can't say no, correct? But
Correct.
anything else, because of the law of co-tenancy, we need to agree on.
Exactly.
Okay, good.
In the third declaration from the trial court follows that language, not the restrictive covenant language, and straightforwardly says defendant's exclusive use and possession of the surface estate of the surveys is limited to hunting and grazing purposes. And that's the agreement.
So if we don't have a co-tenancy, then we don't have a restriction, correct, on the use?
Right. If we don't have
We
a
don't have- Let me rephrase it. I'm sorry. If we don't have a co-tenancy, then we can't, A and B cannot come in and tell Rancho Viejo what to do. Is that correct?
I think the argument would be more narrow. That is, A and B would have standing because Rancho Viejo is a fiduciary to them on those surveys. It goes back to the original one, the findings 2 and 4, the declarations 2 and 4. I think that would still be the case. But
So what you're saying is, if we find that there's no co-tenancy, but we find that there is a fiduciary duty, then through the fiduciary duty, they still have to seek permission from the co-tenant, from the other party, from the person who, the surface, I guess from the other party.
right, exactly. Exactly.
Mr. Posa, but is it the fiduciary duty that requires authorization, or is it the co-tenancy?
Well, this is interesting. This is why it's hard to understand in any sort of fashion if there's no co-tenancy what we're really doing here. So, for instance, I think they all agree that we had standing, even though we weren't co-tenants, to complain about, as did GLO, to complain about putting this facility on the property because we're owners of the soil. Now, how can we be owners of the soil without being a co-tenant? I think that's not possible. But if the court wants to have, for purpose of the argument that Justice Alvarez raised, we're going to have a situation where we're not co-tenants. We don't have a present right of possession, but there's no question that we are, under Rancho Viejo's view, somehow still owners of the soil, somehow. And because we're owners of the soil, and because we did get the benefit of our bargain, at least vis-a-vis mineral development, then we're going to have standing because we're beneficiaries of their fiduciary obligation to not impair, inhibit, or destroy the development of the underlying mineral estate, as is GLO, which has standing.
But the fiduciary obligation came as a result of the 98 stipulation, correct?
Correct.
And your co-tenant argument arose as a result of the 1990 cross conveyance.
Correct.
So the timeline kind of breaks my brain a little bit there.
Well, in our view, of course, we're co-tenants in 1990, right? So the proposition being put forward here is we're not co-tenants in 1990. And for some reason, we're entering into an agreement about use and possession, even though we're not co-tenants. So we'll just get past all that somehow for a second. And then in 1998, although I think it's implied in the 1990, because I think the law implies that someone who has effectively the executive right, each party had the executive right in these properties, and that right involves this fiduciary obligation, but there's no question it's not made explicit until the stipulation in 98. So, but I agree with I think I'm agreeing with you that if there's no co-tenancy, if we entered into an agreement for use for no reason, apparently on page 2, and in 1998, we make explicit what the executive right would be with regard to this mineral development.
And apparently I'm making it a habit today of waiting until the 11th hour to ask the question about what our judgment should look like. But let's say we somehow agree with you on the co-tenant aspect, but disagree with you on the restrictive covenant language. What does our judgment read? Because there isn't a restrictive covenant, because what we're looking at, that's why I started off with the trial court judgment, not the arguments, not ANB's arguments, not Rancho Viejo's arguments. If we're co-tenants, we entered into an agreement, and that agreement provided that we could, each of us, ANB and Rancho Viejo, could maintain exclusive possession, notwithstanding our present right of possession, but limited to purposes of hunting and grazing. And the trial court doesn't call it a restrictive covenant. And I don't think it's, basically to me is, are they a use other than hunting and grazing a violation of our possession and use agreement? It is. Therefore, declarations are affirmed because they're attempting to make uses beyond our agreement. They are, certainly we could have another agreement. It was, as I mentioned, it was modified in the stipulation, but it requires an agreement. We believe, co-tenants, and as co-tenants, we each have rights and we can reach agreements. And when someone attempts to breach that agreement, or in fact breaches that agreement, this facility would breach that agreement. It's not hunting and grazing. Then we have the rights to enforce the agreement we reached in the cross conveyance. And that is recognized by the trial court and should be affirmed as such. So even though the restrictive covenant, our judgment would say the restrictive covenant isn't established as a matter of law, we would still need to remand for a discussion of the injunction? No, I don't think so. Because the declaration, we're affirming or reversing declarations, not what people say they are. And the trial court does not use restrictive covenant. So here's what we would be affirming, that the parties' agreement on use and possession included limited use in order to remain in exclusive possession, limited use to hunting and grazing. And as a matter of law, that's what the agreement means.
So Mr. Posa, is ANB abandoning its restrictive covenant arguments?
We're not abandoning our restrictive covenant argument. We think that's what we think when you agree in covenant in a real property document, that's what you're doing. The trial court did not see it our way. We did not appeal it. I mean, if you take the trial court's declarations as not, it doesn't use the term restrictive covenant. We didn't appeal that. We don't think it's necessary. I mean, there's no question that a solid waste facility is not hunting and grazing. We are confident we're co-tenants. We are confident we reached an agreement. We're confident solid waste facility is a breach of that agreement. And we think the trial court's declarations are consistent with those views.
Any other questions? Thank you very much, Mr. Posa.
Thank you.
Tomorrow you have 10 minutes.
I want to start with the restrictive covenant point. If we can't use this land due to language that appears in the cross conveyance, that has to be a restrictive covenant. So either there's a restrictive covenant here or there isn't, but there's not some restriction that's not a covenant, but still prohibits us from using the land and still requires us to get permission. So I agree with Mr. Posa that the trial court's judgment does not use the word restrictive covenant. but that declaration stands or falls on the existence of a restrictive covenant as a matter of law. I want to point out about the
About the
restrict.
co-tenancy, though, that kind of bothers me. Assuming that there is a co-tenancy, that we find a co-tenancy, how do you explain the 1990 cross conveyance?
Well, if you assume there's a co-tenancy, Your Honor, I think this is a much easier case, and that's what ANB does in their brief. But you can't. I don't believe that there is a co-tenancy here. And one thing that was absent from ANB's brief and from the argument was the statement of any point in time ever that ANB has ever had a possessory right in these tracts. Now, parties made clear using clear language that the cross conveyance conveyed a single interest at a single point in time, specified down to the second, that was for all purposes to take effect only at that time. So the argument that you can start at the top of this agreement and that the clock ticks with you as you read through it has no support in the case law or in ANB's brief or as a matter of common sense. This is a single interest that is not possessory. So the instrument uses the word fee simple, but we don't get to stop at that word. The interests here are undivided. The fee simple is about whether the land can be conveyed or devised. It's not the end of. It's
But
not
you're
the end.
talking about possession. What about use, though? What about the other little stick that the bundle of rights in a fee simple use? And that's, I think, what the appellee is saying, that you have a restriction on the use, even though you're not the possessory, you're not in possession of the land.
Your Honor, that argument has no support in this instrument. The instrument gives Rancho Viejo both exclusive use and exclusive possession. So I don't think in this case we need to define the differences between those terms, because Rancho Viejo has both of them and ANB has neither.
What does ANB have then?
ANB has a surface interest in this land that allows them, one, to receive the surface use payments. And we know from the record at page 1029 that these disputed tracts have indeed been used for mineral production. So they have that. And number two, they can sell this interest. Rancho Viejo cattle conveyed.
Where would they sell just that interest? In other words, they don't have the right of you to use, or they can't say anything about the use of the property. That's what you're saying. They don't have possession. So, I mean, they don't have a fee simple then.
Your Honor, I think they do have a fee simple. A landlord has a fee simple in his property, even if it's leased to a tenant and the landlord doesn't have possession. So possession and ownership are two different things here. And Rancho Viejo kept possession, and that doesn't defeat the fee simple conveyance. ANB still has a fee simple ownership, surface ownership, that they can receive surface use payments as a result of, and that they can devise or convey as they wish. And so I think that right there meets the definition of a fee simple ownership. Just as a fee simple ownership would, if the land isn't divided, include all the interest. Here, without this language, it would have included a possessory right, but this language expressly set forward that Rancho Viejo would retain that possessory right. And because of that, there can be no co-tenancy. ANB cites no cases, and there are none, that hold that a co-tenancy exists without a possessory right. ANB says, well, if we're not co-tenants, then what do we have? But co-tenancy is not at the bottom rung of the ownership ladder. If you don't have a co-tenancy because you lack possession, the cases we've cited, Laster and Sparks and Reed and others, say, well, you just have joint ownership. So it's not as though co-tenancy is the only kind of interest that ANB can have here. If they had ever had a possessory right, they could be co-tenants. But without that right.
Are you asking us to create new law by saying that a fee simple can be divided the same way that a mineral interest can?
No, Your Honor. I think possession is one of the things that by default would accompany a fee simple ownership, but here the parties made clear that possession was not part of the transfer. And the law is filled with ownership interests that do not include possession. As I said, a landlord has fee simple ownership of his property, even though he lacks the possessory right. So I don't think, I agree that possession is by default would be part of fee simple. But if the parties choose to withhold it, they're free to do that. And I think the Laster case shows that, and the Sparks case and others that we've cited in our brief. I do want to speak for a minute about the judgment. And we have this at tab D of the bench book, and I agree with the way opposing counsel explained this judgment is structured. So what we have highlighted, or what we have boxed off in red, is the declaration that Rancho Viejo has no legal authority to use the tracks for what we call the project. And that declaration stands or falls based on the other three. So it's not a conclusion of law. If you get rid of co-tenancy and then there's no restrictive covenant, then this declaration cannot stand. I do want to mention about the fiduciary duty. We explain in our brief why we presented the issue the way we did and why we argued it the way we did in our opening brief. And that's because the judgment, if you read it closely, says that Rancho Viejo is a fiduciary. And then it goes on to state one consequence of that fiduciary relationship. So we had to decide what the scope of the initial statement was, the fiduciary statement. And we argued that the scope was narrow. And ANB's brief, they agree that the scope was narrow. And they state that explicitly. They say at page 40 of their brief that the trial court held that Rancho Viejo, the trial court did not hold that there was a broader fiduciary duty. So I agree that fiduciary point is not foremost, and is not among the foremost issues in this case. And so that leaves co-tenancy and restrictive covenant. And I want to come back to where I started the rebuttal, which is ANB says, well, we've got a restriction, but there's no restrictive covenant. And the response to that argument is the definition of a restrictive covenant, which is if there's some instrument as a matter of law that prohibits Rancho Viejo from using their surface for any purpose they choose, the name of that restriction is a restrictive covenant. And the law tells us how you form a restrictive covenant. So you can't evade that law by saying, oh, it's not a restrictive covenant. It's just a restriction that prohibits certain uses and that requires consent. I don't think that argument can carry the day here. I do want to point out as well that these tracks, as we show in our brief, have been used for other purposes. They've been used for permanent residential structures.
Was there an agreement for that?
No, Your Honor. No, and the stipulation, by the way, the stipulation contains language about how the parties will divide the profits from the sale of water. And we know that water is part of the surface estate. The stipulation, to be very clear, does not give the parties right to sell water. It just states how they will share the use. So, or how they will apportion the profits from the sale of water. So when the stipulation was entered into, nobody thought there was a restrictive covenant here. They were talking about how are we going to sell water, which of course is not included in the hunting and grazing purposes.
Any other questions, Justices? Well, thank you very much for your arguments. They really enlightened the case, and your case has been submitted. We will issue an opinion and a judgment as soon as practicable. And if you wish a recording of this hearing, please contact our clerk of the court, Mr. Cruz, And that's it for today. Thank you very much.
Thank you, Your Honor.